Very good afternoon to you, and many thanks for staying with us. Now, it was the third day for the interviews for the next Chief Justice of Kenya before the Judicial Service Commission, and the head of the Appeals Court in Kisumu County, David Maraga, was the third to take the stand before the Judicial Service Commission. Let's cross over at the Supreme Court and listen in to how the interview is ongoing.
And see whether within the context of your jurisdiction, how you would apply it to give a remedy. But the fundamental point is jurisdiction. As I said, the extent to which you can go within that jurisdiction. You're not just confined to do this, don't do this, don't do this. The court is not confined like that. I mean, you are, as long as you are operating within the sphere of the jurisdiction that has been given, I think you can expand and provide remedy where the law is silent.
But Judge, you know my concern, my problem with the Wasami school of thought that is now clear on the restricted jurisdiction is that had your decision, for instance, in the Obado case stood, we would be having a different governor in that area of the country, isn't it? Because you made a decision in Kisumu on the petition touching on the elections in Migori County.
Not as an individual, but my court did.
No, the court, yes, the court.
Yes.
So the point is, the question is on 163.4a. Wouldn't it be your view that there is need to have a final court on this question, on the question of the interpretation of electoral law? As a matter, even if you went to 163.4b, of public importance, by extension, isn't the election of a governor or of a member of parliament, let's look at 164b, a matter of general public importance, given your earlier explanation that a petition challenging the election of a member of parliament or a governor is a matter that concerns the general public?
I don't think so. My view, Honorable Commissioner, is that it is not the position of the person you are dealing with that should be given primacy in what you are dealing with. And I go back to the jurisdiction in election matters. It's a sui generis jurisdiction supposed to last for a short while, a period of time. If we are going to say the election of a member of parliament, because he's a member of parliament, is a matter of national importance, we go back to where we came from. We go back to where we came from. And when you deal with the Supreme Court, you know, is one bench. If you have all those matters coming there, in fact, in my view, given the interest that has been generated in elective positions, you can even have matters pending in court for 2 terms, simply because the Supreme Court cannot handle. I agree, there could be areas where errors are committed. Those ones can only be corrected in the next election.
Now let me go to those,
because you know, I mean, let me finish. Sometimes you don't get a perfect solution. You don't get a perfect solution in some of these areas, and there are quite a number of areas where people have gone without a remedy, even if they feel aggrieved. But then there must be finality to litigation, and in my view, when you come to election matters, litigation, the most we should allow is one right of appeal.
Okay. Let's move on.
Thank you.
And I'm happy that is until the law is amended. But let's move on. You have rightly admitted that there is need to amend Article 163.4a and b, isn't it? A, so that you say except in elections.
Yes.
Did your committee submit that proposal to Okoa Kenya, to the amendments to was Okoa Kenya and another group. Did you submit that proposal for amendment to the group that wants to amend the constitution?
Okay, no, we didn't
To submit to me.
we didn't do that because what we did, when these proposals came from the judges and the magistrates, and because of the issue of public participation, we involved the other stakeholders, the governmental stakeholders, the civil society, and the political parties, and they made those proposals. In fact, those are not proposals coming from the judiciary alone. They are coming from all these other stakeholders, and then we made them.
But you hold the view, Judge, therefore, that there is need to amend the constitution in that respect.
Yes, to bring to finality election matters as soon as possible. In fact, my understanding of the constitution is that these are matters which should be finalized within a year, so that the country moves on.
Judge, I ask you this question because I know that you are foremost expert in election matters. But look at Section 32 of the Elections Act, for instance, on scrutiny. We have different decisions from different courts on whether scrutiny should be directed at the polling station or to the bigger unit, or for all, and there are different decisions that have been made by courts.
Yes.
How do you deal, or how do you intend to deal with the different findings or different judgments of different benches of the Court of Appeal on elections? And that's the problem. Isn't it, therefore, only a godsend that the Apex Court dealt with these questions?
The issue of scrutiny, I wrote a chapter. It is one of my writings in this book.
You know, that's why I said you are the foremost authority.
Yes.
You are correct, but I'm saying,
Yeah.
how do you deal with the other rulings
Yes.
or judgments
Yes.
where there is misdirection by a bench of the Court of Appeal of equivalent jurisdiction, and where you consider the law, you have different findings by different benches? What does one do?
Deal with them in the next round of petitions, analyze them, and because the Court of Appeal is also not bound by its judgments, it can review them and depart from them, and a consensus in most cases comes, and you find that judges even admit by themselves that here I think we had.
So,
but as I told you, you have got to premise it within that jurisdiction. Even the general jurisdiction of the Supreme Court, by the way, given the wording of Article 163, 4A and B,
yes.
it is not going to correct every ill that has been committed. Even forget about the election matters. That's why I told you that it is not in every situation that you get a perfect answer to a problem.
Now let me bring you closer home. You are aware of the intended amendments, I don't know whether they're complete, of the Appellate Jurisdictions Act Court of Appeal Rules 2010 on the dealings and the delays that are caused by the backlog for applications under 5.2b.
Yes.
How do you intend to deal with this matter to ensure that once a wrong decision is made by a high court, that a party can immediately appear before a single judge and get a stay in the Court of Appeal without the longevity that would by then have led to the loss of the subject matter or the change of the status of the subject matter, the subject of litigation?
To avoid a situation where even perception, people look at some of those decisions as forum shopping. You are looking for a judge who can give you a decision on this and you stay and what. To avoid that, in fact, that issue had even come before as a Court of Appeal. And we said other than procedural applications, all substantive matters requiring substantive orders must be made by the court. What I would do and this is what I have endeavored to do in Kisumu, is to have those matters heard as quickly as possible. And that
Presiding Judge of the Court of Appeal in Kisumu, David Maraga, there answering two questions before the Judicial Service Commission during his interview for the position of the Chief Justice of Kenya. And currently interviewing him was lawyer and Commissioner of the Judicial Service Commission, Tom Ojenda. This interview has been ongoing since morning, and at this point we'll link up with our reporter Michelle Ngele, who's joining us from the Supreme Court to give us more details on some of the things that went down since the interview began in the morning. A very good afternoon to you, Michelle. Many thanks for joining us. What exactly has been the line of questioning for Justice David Maraga?
Well, like you just saw, everything seems to be going smoothly for Justice David Maraga. This is a man who is deemed to be one of the three front runners of this judicial supremacy battle. And this morning, of course, he was taken to task as to the allegations or questions on his own integrity dating back to 2012, when the Law Society of Kenya accused him of bribery and dishonesty, as well as using his ethnicity to influence his judicial processes or his judicial duties. But this is something that he defended himself against after appearing before the Judges and Magistrates Board back then, and he also defended himself again this morning over the same allegations, of course, which he has since been cleared of. But the first thing that he did, Akisa, was talk to us about his judicial reform agenda. What would he do in his first year in office after being elected Chief Justice, or being appointed Chief Justice rather? And the first thing he said he would do is restructure the office of the Judiciary Ombudsman to make sure that it is being headed by a senior or retired jurist. And this, he says, would be people who are best pleased to deal with complaints against senior judges in the judiciary. In the same manner, he also says that he would open an email address where these cases or these complaints can be forwarded. In this day and age, of course, suggestion boxes having been phased out by technology. But his religion, Akisa, also came into play in this questioning here today. He was asked about the very controversial topic of abortion. What does he think on that? And being a very staunch Seventh-day Adventist, he says that conception, or life rather, begins at conception. And so terminating a pregnancy after conception without doctor's orders would by all means be deemed illegal, not just by the Constitution, but by his religious beliefs as well. And we also saw his religion come into play when he was asked about euthanasia, or mercy killing as it is commonly known. Of course, again, saying that it is illegal in the law in Kenya to carry out euthanasia, but also with his religious beliefs, he just doesn't believe that any human being should have the right to take away a life, because life, he says, is sacred. And so we're seeing a different side of Maraga here, his religion really coming out to play. But it also almost put him in quite a tough position when he was asked what would he do if he was sitting a case that extended all the way to Saturday, when he's supposed to be in church on Saturday. And he remained very categorical that he would not sit on a Saturday because he was expected to be, to be in church at the time. And so these are just some of the things he has been asked about. How conversant is he with the Constitution as well? He came a bit to pains when he was asked to mention 3 female senators. Although he did manage to mention 3, it was quite difficult for him. He couldn't mention where they were from. And so these are just some of the things that are coming out. These judges are required to be very conversant with the Kenyan Constitution. Akisa.
Very interesting conversation there, but quickly, what exactly do we expect in the afternoon?
Well, just a few remaining panelists are yet to question Justice Maraga. Of course, his questioning is expected to end today. Tomorrow, we do expect lawyer Nzamba Kitonga to be questioned before the panel as well. But like I mentioned, Akisa, David Maraga was deemed to be among the front runners in this race. And this last leg of questioning will really, set the pace for him as to whether he really is one of the front frontrunners. He does represent a minority community, not coming from the central region and not from the Rift Valley region as well. Kenyans have really complained that the top judiciary top dogs mostly come from those areas that are influenced by the president and his deputy. So the very fact that he comes from Kisii land, first of all, should he be appointed as Chief Justice, he would make history as the first Kenyan from that region to clinch the position of Chief Justice. So just the last bit of questioning by David Maraga, and we will be able to gauge his performance as the performance of the other two judges that have appeared before the panel. Akisa.
All right, thank you very much for that update, Michelle. Michelle Ngele is our reporter joining us from the Supreme Court, where David Maraga is currently being interviewed by the Judicial Service Commission for the position of Chief Justice. And something very interesting has just come out of that conversation we've just had there with Michelle Ngele, the line of questioning by the Judicial Service Commission. And they asked about euthanasia, which is a mercy killing, and of course the views of David Maraga and how he would handle this if he had this particular case, a conversation that has been going on for a very long time. And at this point, I will bring in Dr. Mercy Korir, in-house doctor here at the Standard Group, to just let us in on her views on euthanasia. A very good afternoon to you, Dr. Mercy. Many thanks for joining us.
Good afternoon to you, Akisa.
Yes, and this is one of the peculiar things that came out of that particular interview by the JSC with David Maraga. I would just want to pick your brain on your personal views on this and the kind of laws we have in the country with regards to the same.
Okay, it was quite an interesting line of questioning because in I think the modern day society, doctors and healthcare providers do come across situations where they are caught in between saving a life or letting a life go. And some of the situations, obviously, that would call for euthanasia or what the Western world would do are dire situations where obviously a patient has been confirmed or certified to be brain dead. So obviously at that point, from a medical point of view, from a medical perspective, this person is in a vegetative state and would probably not have any quality of life afterwards. So at that point, then usually the question comes, do we continue to have this person on life support knowing they may not have any quality of life afterwards, or do we let them go? So unfortunately, in our country, we don't have express laws that guide on this, and it was quite a good line of questioning by the AG there. And most of us in an African setting, death is a taboo discussion. Yes. And religion also comes in, as we saw with Justice Maraga there. And most people are caught between their religious beliefs, their cultural beliefs, and what science would guide. And so with no clear guidelines on that, then it puts both the relatives, the patient, the doctors, and the law at crossroads, really, on whether should this life go or should we continue having that life on life support. And then in our setting, we are resource poor. And so you can imagine just to maintain somebody on an ICU bed in critical condition takes quite a lot of resources. And obviously there's a high need of this. So there's usually what we call you're caught in between withholding treatment or withdrawing treatment. Because when that bed is occupied, for example, you're probably withholding treatment from somebody who needs it. And if you let that life go, then you are withdrawing treatment from that person. So which one is the lesser evil of that? And with no clear laws and guidelines on that, then people are caught at crossroads.
All right. Thank you very much for helping us understand that. Dr. Mercy Korir there joining us via phone. Dr. Mercy Korir is a reporter and, of course, a doctor by profession, talking about euthanasia. One of the things that David Maraga, Justice David Maraga, was asked there by the Attorney General and how he would handle it. All right, at this point,